Welcome to the next video in our series, the 5 most important concepts you need to understand to pass your state's real estate licensing exam. Today we're discussing estates and land. There are many ways to have interests in land, but not all interests in land or estates in land. The technical definition: an estate in land is an interest that allows possession, either now or in the future, and must be measured according to time. The main 2 types of estates that we need to understand are freehold estates, which are ownership interest in land, and ownership lasts for a lifetime or forever. Well, if it's not freehold, it's less than freehold, and another name for that is leasehold estates. Leasehold can be measured in time. If it's your property, but just for the next 5 years, you probably don't own that property. You're leasing that property. Ownership lasts for a lifetime or forever. We have a lot to talk about today just under the category of freehold estates. We're going to save leasehold estates for another video coming up soon. First, let's discuss ownership. Well, when it comes to ownership or a freehold estate, 3 main types that we need to know: fee simple absolute, fee simple defeasible, and life estates. Fee simple absolute is the highest ownership recognized by law. And if you own a home, I would imagine you own fee simple absolute. Before we go too far, let's discuss absolute ownership. Because when it comes down to it, no ownership is absolute. If you own land, you have to pay taxes on that land in most cases. If you own land, you have to follow the zoning laws of the county or city where that land is located. They tell you what you can use your land for: residential, commercial, industrial, agriculture. If you own land that's in a homeowners association, you have to follow the rules of the homeowners association. So no ownership is absolute, but fee simple absolute is as close as it gets. This is a term that you actually take out of these real estate courses and use in the real estate business. Ask any real estate agent, what is the highest form of ownership recognized by law? They'll all tell you fee simple absolute. A good definition: one who has ownership rights that could continue forever, and no other person can claim to be the owner of or have any ownership control over the property, has fee simple absolute ownership. Okay, well, not easy, but we can understand this. Fee simple absolute, as opposed to fee simple defeasible. What does that sound like? Fee simple defeasible. Ownership that can be defeated. Ownership that comes to you on a condition. If the condition is broken, you can lose ownership. Somebody wills their home to their church or their land to their church, so long as the land is only used for religious purposes. If the church ever decides to use the land for any other purpose, the former owner, in this case the owner's heirs, can reacquire ownership. Well, under defeasible, there's 2 categories: fee simple determinable and fee simple subject to a condition subsequent. I don't think we have to get too far into this. Just simply understand the concept. With fee simple determinable, if the condition is broken, ownership automatically returns to the person named. With fee simple subject to a condition subsequent, the former owner or heirs would have to go to court to reacquire ownership. Fee simple determinable, there is a person named as the possibility of reverter. Another term to be familiar with under fee simple determinable: possibility of reverter. This is the person that ownership can revert back to if the condition is broken. Now, if the possibility of reverter passes away, they're going to will that interest to somebody else. And when they pass away, they'll will that interest to somebody else. 500 years down the road, there's somebody named as the possibility reverter. And is that not an estate in land, an interest that allows possession either now or sometime in the future? With fee simple, subject to a condition subsequent, the former owner or the heirs has the right of re-entry, but must bring legal action in court to assert that right. Then we have life estates. Something a little bit more creative. This is ownership given to somebody based on their lifetime or somebody else's lifetime. An elderly gentleman is remarrying. He owns a home, and when he passes away, ultimately he wants his family to regain ownership, but at the same time he wants to take care of his new bride. So in his will, he writes instructions that says when he passes away, his new bride will have a life estate in the home. The new bride will own the home for the duration of her lifetime, but when she passes away, she will not be able to will her interest to her family, because that interest then would return to the original owner's family. Life estate, ownership based on somebody's lifetime. The owner is called the life tenant. Ownership can be measured on the life tenant's life, or we can name somebody else. Pour autre vie, for the life of another. The life tenant owns the property based on some other person's lifetime. In fact, this is where life estates originated. Back in the days of the kings and the knights. You know, back then everybody wanted to bump off the king, and the king was looking for protection. The way you had wealth in those days was not by money, it was by owning land. So the king told its people, I'm going to make you wealthy by giving you land, but you only own this land while I'm alive. If I pass away for whatever reason, my family is going to regain ownership. Now everybody wants to protect the king so they can maintain their wealth. This is pour autre vie, for the life of the other. The knight owned the property based on the lifetime of the king. Well, thank you for watching our video, Estates in Land. We're hard at work on our next video in this series, the 5 most important concepts you need to understand to pass your state's licensing exam. So subscribe below, you help us, and if you hit that bell, we can let you know when our next video is available.